If you're in Medina, Summit, or Cuyahoga, there are certain rules that your family law attorney needs to be talking to you about, and I'm here to talk to you about them.
You said a couple of years ago, Medina County, they changed some rules around. There's some reorganization, and there was some overhaul to those local rules to standardize operations. Someone that's like Brunswick, Wadsworth, like court rules sound like this dense legal jargon that I, like even me, I glaze over a little bit. And I realize that if I'm dealing with a family law attorney, I probably should know something about, but I don't. What's the single biggest challenge that some of those local rules that changed, like what's the biggest challenge, or how do those directly impact how quickly a case moves from, hey, we're angry at each other, to a final resolution?
Well, no case moves quickly. I mean, in the ideal world in Ohio, you can get, once you file for divorce, you can get a resolution 42 days after you file the divorce and have it served.
Oh, wow.
And Ohio has a cooling off period for divorces. However, I've had one 42-day resolution in 14 years of doing this. It's a unicorn. But prior to Judge Julie Schaefer, was appointed by Governor DeWine. Prior to Judge Schaefer, there wasn't really an impetus to do anything in Medina County domestic relations. Quickly. And well, not just quickly, but nothing. Like they had some rules about when to file stuff and what you were supposed to do, but it was never enforced.
Okay.
Because you were never going to trial. You were never going to trial under the old administration. And so when Judge Schaefer took over, one of the things that she told the members of the domestic relations bar is, there will be trials if you want them, and I'm going to have it so that people are ready on the day of trial. Because when the past judge was there, stuff would just get continued and continued and continued, or had to be dismissed and refiled. And because the other judge's philosophy was everybody should just figure out how to settle this. And so there's been a lot of rules implemented by Judge Schaefer to have people trial ready on the day of trial. I will tell you that the success rate is not great from my perspective. A lot of attorneys don't follow the rules. Sure. I follow the rules. I'm a big, strict rule follower. Sure. And so when the judge says, hey, you have to have this in by this date, it's in. It's in. That's it. I don't have to worry about it. But a lot of attorneys don't do it. But the court has started cracking down on those. And if you're trying to represent yourself, you're frankly, even with ChatGPT or Claude or anything, you're not going to do it right. And
because of those rules? Because
of the rules. I mean, you have to know what you're doing. You have to know what a pretrial brief means, right? And you can feed that to ChatGPT all you want, but the court actually has a local rule on the use of AI in filing briefs.
Really?
Yes, there's a new local rule. Mm-hmm.
Interesting. So there's these idiosyncrasies that can change. But does this help speed things up? Does this help get some resolution for people in many cases?
No.
Okay. So, but this does give the option for trials. And you definitely, I don't want to say enjoy the trials, but you like the fight.
I love the fight. I love it. It's the best part about being a litigation attorney is being able to put the opponent on the stand,
sure,
and just mow them. And you try to get your client to not be mowed,
right?
And then that's it. But at the end of the day, trials are not good for anybody.
Sure,
under very limited circumstances is a trial helpful.
Okay.
But they're not. They're incredibly expensive to try a case.
Sure.
My average trial retainer is $7,500, and that's just for trial.
Just to start.
Because it's a mess. Usually it's a full day. You've got multiple witnesses. Sure. You've got all the prep time in front of that. You got the prep time with your client. And at the end of the day, you have no idea. I mean, you have some idea,
Right.
But you really have no idea what the court's going to do.
Right.
And so the court can do anything within their abilities to divide assets and liabilities and parenting plans. And then once the court writes it, it's very hard to undo that.
Right. It's in pen. It's not in colored pencil.
No. In fact, I've had trials where we got the decision and then we had to get together and make a different agreement after the decision because everybody hated the decision.
Interesting. Okay. So there is that back and forth, and there is that working to find that resolution on it. The fact that you're willing to fight is a big deal because that makes sure that people know you're not going to back down.
Well, I'm not going to back down, but the whole key is not having to be put in that position. There's no reason adults can't get into a room and figure stuff out no matter how much you hate your ex, right? There's no logical reason. And I tell them, this is how much money this is going to save you. Don't pay me, put it in 529s for your children, right?
Yeah.
Like, look, I love making money just like everybody else, but that's not the way I want to make money.
Right.
Right. Like, I'm not going to fill these people's heads and lead them down like the primrose path to agreeing with them on their completely illogical stances on, I deserve 100% of the house. Well, okay. Well, that's never going to happen.
No,
I'll go do it at this expense. And you're going to give them 50. So why don't we just give them 50 today and not pay me, right?
Once again, the honesty in this is what I truly love, because you made reference in the last episode to the used car salesman, and I've seen that out of so many lawyers. They have the used car look. They have the used car salesman approach. Yeah. The transmission's fine. Just drive it. Just get it off the lot however you can. The fact that you're not trying to oversell or upsell to me is a huge bonus. Sticking back to some of like the local requirements in that, there's all the detailed affidavits. There's basic information, income, expenses, property that have to happen right up at the start. Mm-hmm. What is the single most common paperwork blunder, mistake, whatever, that someone makes on those initial filings that stalls cases before they even get moving?
We actually sit down with clients and help them fill it out, because for 10 years, I had them fill it out. And they were never right. And I tell them, listen, I'm not going to knock on the highest Supreme Court designed these forms. So God bless you, Ohio Supreme Court. But there's way more stuff on these forms than ever would need to be disclosed, right? There's grass cutting. I think there's a grass cutting line on there. Why? Like, who cares how much the grass cutting is, right? And the affidavit of expenses, like the court doesn't care, right? Nobody cares. Why is it on there? They could simplify them to make it easier for people to be able to fill them out.
Sure.
But since again, it's just one of those things from my perspective is, when we had them fill out the affidavits and the UCCJEA, which is the Uniform Child Custody Jurisdiction Enforcement Act paperwork, if you have children, that is also a very laborious paper to fill out. And so I found that we were going back and forth, and so much staff time I'm charging the client to do that, to look through them. Okay, no, you got to redo this. So we just started bringing them in. And it's a couple hours, and I get that that's an expense, but it'll be way less stressful on you than having to sit at home wondering what gross wages are versus net wages, and how to calculate your own overtime and what your mortgage payment actually is. And people don't know their mortgage payment, which always boggles my mind. But
so you guys walk them through that step-by-step process to make sure that they're getting it. I mean, look, most people hire out their taxes. This is even more in depth than your taxes, I'm assuming. And why not have you guys along for the ride to show them what they need to fill out with that, right?
Well, it speeds things up.
Sure.
And I look at it as providing a comfort level where you're not sitting there at home trying to fill these out. And the other thing I found is that people they rush. Like if I got people set out paperwork today, they send it back in the next day. And then I look at it. Did you even look at you missed like 17 boxes, right? Like take your time. Let's do this right. Don't have me review it and charge you to review it to make sure it's right, because I have an obligation to review it before it goes to court. I can't just submit it, because if it's wrong, I'm setting my client up later. It's a sworn affidavit.
Sure.
So if it's wrong, they've perjured themselves.
Yeah, that's usually not a good thing.
No, it's not. And believe me, it's the first thing attorneys look at.
Oh, sure.
Who do this are the affidavits. And you look for missing items, which then becomes a hot box later. If somebody doesn't disclose a 20-foot boat that we know that they have, that's because you're required to provide full disclosure. Sure. And so if bank accounts end up missing on there, or you find hidden assets that they didn't disclose, sometimes they'll give people the benefit of the doubt and say maybe they just forgot.
Right.
But by and large, I don't think that they forgot, because when you typically find those accounts, there's large sums of money in them. And then maybe they just didn't think somebody would do the work to find them.
Right. And I get it. It's you and opposing counsel's job to find those things, to make sure that this is fair and equitable as much as possible. Finding those things is, once again, if you find that error, that I don't want to say is weaponized, but in a way it can be. So make sure that you fill it out right the first time, so someone doesn't have the weapon against you. Is that kind of the moral of it?
Well, absolutely, because there's a statutory language about financial misconduct in a divorce where you can get triple damages plus attorney's fees. Okay. And so, yes,
that's real expensive.
So if you don't disclose a $100,000 asset, right? I mean, you can end up getting a distributive award to the other person for $300,000 plus whatever it took me to go down that path to find it. Yeah. Because it's supposed to be penal, right?
Yep.
You're not supposed to do that. If people didn't do that, this would go a lot easier.
Yeah. So it is a don't do that with teeth.
Yes.
So let's talk, speaking of financial information, if one party's dragging their feet, they hold stuff back, like how do the rules handle that non-compliance in terms of they didn't get to it yet? Or, I'm sure you've seen it where someone's dragging their feet. And typically when it's divorce time, this is a process that people want to just get through and get behind them. So
I actually don't think that they want to get through and get behind them, or else they would do what we asked them to do and what the court asked them to do, because that would definitely move things along faster. When you drag your feet, you're only prolonging the agony in getting this thing done. I have very tight time schedules with my clients, and I say, listen, I want these documents back in 3 weeks. And if they're not back in 3 weeks, the staff is calling them every single day until I get them, because I need them and I want to be out ahead so that I can get this thing done. Right. But the court, so the civil rules prescribe how that's all supposed to work. Okay. The civil rules say that we send them discovery. They have 30 days to answer that discovery. On day 31, I can send them what's called a good faith letter that says, hey, you missed the deadline. I'll give you another 14 days. Hardly anybody sends that letter on day 31. I usually try and send it around day 40, just to give them a little extra leeway, because you think 30 days is a long time, but it's not.
No, it's a lot of information.
A lot of information to gather. But day 40, that letter's going out. And then if they miss the deadline again, I file what's called a motion to compel. Okay. And motion to compel is requesting a court order that the person turn over those documents.
Okay.
And then if they don't, they can go to jail. You file a motion to show cause.
That's a bad day.
They show up for a hearing. The court can't arrest them and put them in jail. But from the good faith letter through the motion to show cause hearing, you can get attorney's fees for all of that work, because you're not supposed to have to do it. Gotcha. People are supposed to voluntarily participate in the process. So you can get attorney's fees. I typically tell people you're probably not going to get back everything you spent.
Sure.
But then the court's definitely formed an opinion about your spouse at that point.
Sure. Not helping move the process forward.
Correct.
Not an active participant. Maybe that's the right way to put it. I want to dive into some like shorter questions on this too as we start to
Like
wrap
hot
up.
takes.
Yeah. How long from start to finish? Let's say Medina County.
Yeah.
Start to finish. How long does a typical like contested, not a friendly? How does a contested divorce actually take?
Well, it depends on if you have children or no children.
Sure.
So contested divorce with children can take up to 18 months.
Okay.
A contested divorce without children is 12 months.
Gotcha.
A parentage case, that's unmarried parents, one party filing a complaint against the other parent. Those are typically 9 months unless child support's involved, and then it's 12 months. Those are supposed to be the limits. If you go to Cuyahoga County,
Sure.
those are not the limits. Those are more like polite suggestions. Cases can go on forever. Okay, I'm thinking of Sandlot right now. Forever, right? It's a totally different world in Cuyahoga County than it is in Medina. And if you see a magistrate instead of the judge, so sometimes the judge takes the case, sometimes she passes it off to a magistrate. That timeline goes down a little bit because the magistrate has to hear the trial. The magistrate has to write the ruling. There has to be the time for the objection and the time for the judge to write the objection before the expiration of that 18 months. Okay. So typically you're probably looking about month 13 for a trial with a magistrate in a contested divorce with children so that the timeline sticks. But as I always tell people, I get in a lot of trouble. I do because 13 months could mean 14. It could mean 12.
Sure.
Right. It could mean 16.
Right.
I tell people when I say numbers,
Ish.
it's ish, right? I don't control the court.
Right.
The court tells me when to show up.
Right.
Right. The court is nice enough to give us dates.
Yep.
It used to be old administration. They would just send you a date, didn't care if it worked with your schedule or not. And that led to a lot of continuances.
Oh, sure.
Well, the court changed that now where if there's 2 attorneys on the case or 3 or 4, you pick dates that works for everybody. So there's not a lot of rescheduling.
Awesome.
But that also means when you're trying to get 4 attorneys on the same schedule, that it might be month 12, it might be month 16,
Sure.
right? And so when I say 13, people are like, well, it didn't happen at 13. And I was like, yeah, dude, like, come on.
Wiggle room. That being said, 2 last quick ones. One, can we bypass standard court timelines? If my spouse and I agree on everything midway through, we're like, you know what? You take half, I take half. We're good. Can that condense it?
Absolutely. You can settle a case anytime. If it's in the divorce, you can settle it anytime after 42 days up until the date of trial. So literally month 1, month 2, month 3, month 4, month 5, you could absolutely resolve it. A dissolution is a agreement process between 2 parties.
Sure.
That can be done 30 to 90 days after the paperwork is filed, which is really the key word there.
Yep. Is
the after the paperwork is filed. Because if you take 2 years to do the paperwork, you're not divorced for 2 years, 30 to 90 days. So
that's a long time.
You can't.
That's an eternity.
Yeah. The court, if you tell the court you have an agreement, they're going to get you on the schedule whenever they get you to get it off of their plate.
Sure.
So they're very excited when people resolve cases.
Love it. Last question. Someone in, like, let's say Medina, Summit, Cuyahoga County, they receive court papers tomorrow, or they're getting ready to file. What's the first thing that they should be thinking about so they don't compromise their position early on? Because I'm sure you've seen some people that are like, I just received something today, and they instantly do something to stomp on their own foot.
They do all the time. Don't move assets would be my number one. Don't move assets. Don't empty bank accounts. Don't put loans out on your 401k. All that stuff makes my job a lot harder later. And you may not be doing it for nefarious purposes, but it sure crap looks like it if $30,000 that was in a joint bank account and then it disappears the next day. And by the way, it just costs both parties more money when that sort of stuff happens, because the first thing I've got to do is I've got to file 2 additional motions and an order for the court to get that $30,000 back. And those aren't short motions. We're talking about an hour's worth of my time to get those things done.
Sure.
And then they have to look at it. Then their attorney has to respond. And both parties have just cost themselves probably $1,500, $2,000 for sequestering away the 30.
Don't do that.
Just call a lawyer. Call somebody who knows what they're doing. And most people can get a consult with me within a couple of days, depending on my schedule. I've got other attorneys in the office who can do it, and you can talk to a lawyer. Now, I do charge for consults. Not all attorneys do, but I give a full hour. You get a full hour picking my brain, and believe me, I can dump a lot of information out on somebody in an hour about the process, because I do it all day, every day, 365 days a year. I mean, this is 100% of my life.
Yeah.
I'm not obviously saying I'm an expert. There's always nuances to learn in family law that
always new
you
things.
don't know.
There's always that one case that's going to surprise you.
They're rarer these days.
You've been at this long enough that they're
I always say I've already seen everything, and then inevitably, maybe once a year, I'll be like, wow, like I have never seen somebody try to do this before. It's fascinating. I did a couple years ago, I did a common law marriage from Texas here in Northeast Ohio, as to whether they were common law married in Texas or not. And so that was fascinating, because Ohio hasn't had common law marriage since 1992.
Sure.
And these two people in Ohio has to recognize a marriage from another state.
Yep.
And so there was a big question about whether they were married or not pursuant to Texas law. So we had to have the judge interpret Texas law as to whether or not they qualified to be common law married here using Texas law. It was absolutely fascinating. I loved that case. My client was great. It was a really fascinating case.
This goes to show, while you're the lawyer and I'm the podcast host, and when you said you will dump a lot of information in an hour, you've done that in about 20 minutes here. I am excited for the next episode. I am pretty sure everyone out there will be too. Make sure you like, subscribe, and if you've got someone that will be interested, share this with a friend. We will see you soon.